and appeals to order. All of our members are present. Bill Kuchler on the left, Steph Ritter on the left. I'm Albert Sharp, Ron Maxwell, and Julie Kuhn. The first item on the agenda is to adopt the agenda.
I so move.
Are there any modifications?
A second.
Okay, Steph moved and Bill seconded. Any other discussion? All in favor?
Aye.
Okay, next item is the minutes.
I have a couple, just a couple of corrections that actually Julie had picked up. On page 2, it's Ms. Ritter, page 2,
Oh, sorry.
I think I'm the one who would have caught that. And then on page 3, in the middle, I know I made this motion, which is probably why I got confused. On the motion duly made and seconded, the board agreed to try to make the findings with the then blank of the front setback requirements.
Oh, with the reduction of the setbacks, it would be
Yeah.
reduction of them.
Of the front, okay.
Or
Yeah, that's with the
the variance to
reduction of the front setback requirements by 25 feet.
With the reduction, yeah, it's missing a word.
I think that, yeah. I was amazed you got it on. Period.
Is everybody good with that, with the reduction of the
Yeah, I
front?
think that's what. Okay, nothing else.
Is there any other? So all in favor of approving the minutes with those changes?
Aye.
Aye. Okay, I think we just have this one item on that one application, which is for a variance from Charles R. Wood Builders. Your
Yes,
there, and your representative.
Greg Ashwell, I'm counsel for Charles R.
Okay. Okay. Shall we, I guess we should hear, if you'd like to.
I would like to start, if you don't mind.
I don't know which way we need to go on this, and with the information we got from the zoning administrator today, whether if that's going to be relevant, the public hearing may not be needed.
Well,
So we need to have an understanding of that first.
okay, so the question, if I understood it, is that the lot was created after the zoning ordinance? Is that the issue?
Yeah. I mean, in fact, why don't we have Michelle explain
Yeah.
what she, sent us today, and
So we're just gonna talk about this real
Okay.
quick and then we'll,
I mean, pretty much my email summed it up.
Yeah.
It was just a cursory review of the records and deeds, some boundary lines, adjustments were made in 2005 and 1999. In 1981, there was a plat breaking off an acre, which was approved by Mr. McNear. Back then, it was a 2-acre minimum for the agricultural zoning district, and I'm going to put forth a determination letter in the coming week.
but what was that determination? Is that it's not?
Going into detail of why this isn't a buildable lot.
I was gonna say, basically, the determination, I mean, the lot was legal, but it was not a buildable lot, correct? And that they can make, it's a lot that is,
But I thought that's why you got a variance, was because you had an unbuilt.
no, the lot is undersized, it does not meet the 2-acre minimum.
No, but that's what I'm saying.
Well, then, no, there's no variance on that.
The issue that might be, how did it get created? It was created by approval of the zoning administrator?
Correct, and and to my understanding, there's no, he has the right to do that, because it's in agriculture, and yes, the lot could be used for agricultural purposes, but it's not a buildable lot, correct?
I'm not sure about that. I'm not sure that that applies.
You what?
I'm not sure that that's correct. It may be an error on his part in creating that lot. But I don't know that are there any unbuildable lots that you just can never build on, even with a variance? I'm not sure.
Well, that would be the reason for a variance, right, if it couldn't be built.
But if it's not a buildable lot, there's no need for a variance because it's not a buildable lot.
I don't think that
Well,
is
the
correct.
you mean it's not a buildable lot under any, under
It
any
doesn't meet
possible
the
zoning?
2-acre minimum.
Well, okay, well, I guess we could ask
Okay.
Mr. Ashwell if he has a.
I do have a position on this. First, I did get a copy of the email, and I get which way the wind's blowing from her standpoint, but I'd like to see her actual determination, because she did reference that it was a cursory review of the land records. Secondly, I think we all remember Mr. McNair, he did stamp off on this, and it's interesting to note, based upon our conversation, that the other lot, which was chopped off, is less than 2 acres as well at the same time. So,
You mean the one that we granted?
yeah, I mean, the one that was approved was less than 2 acres at the time, and so.
It has a building on it, right?
It has a building on it, so how can
It has
that be
building.
okay and this one not be okay? And to answer, sir, your question, I think, is it a lot that can be built on? Is it a lot? It is a lot, and I know that some of the members had questions from the last meeting. I did look at the minutes, and I think there was some concern. One of the members said, because they showed to the group with their variance request what they went by. And in no less than 3 different places in that in the advertisement, and I know it does say that the zoning is unknown, but they do make reference to no farmland, or it's I guess that's from a standpoint of rollback taxes. 0.93 acre lot ready to build with approved 3-bedroom certification letter. They have the perk from the health department. They have the okay from VDOT about the driveway, and they have in this advertisement. It looks like an official plat with a building lot on it. So I know from a due diligence standpoint, we need to hold some people to a higher standard. Perhaps if that's the standard you want to hold these particular people to, that's great. I think you need to hold everybody to the same standard. So that issue, and again, there's updated plat shows proposed house location, well location, approved septic, all that is true. Build your dream home. So they buy this particular lot at $28,000 above assessed value. So they come here, they file their request, and I know that some of the members of the board felt like it's kind of maybe a catch-it type situation where, maybe should have looked into it a little bit deeper. So you got a lot you can't build on. You should have looked a little deeper into it. Actually, that's not the standard according to Spence versus Board of Zoning Appeals of Virginia Beach from 1998. In that case, a person, say, Mr. Sharp, you had a lot, and you tried to get a variance and it didn't work. And I come up to you and say, Mr. Sharp, I'd like to buy this property from you. And I come to the BZA and ask for the same variance. And one of the neighbors said, Mr. Sharp just tried to get this thing a variance and was unsuccessful. The Supreme Court said, doesn't matter. It's the essential non-ability to use, and these were 2 triangular lots in Virginia Beach, that they could not build, and they gave them the variance. And that due diligence argument really was not recognized by the Virginia Supreme Court. The 3 things that the board needs to do under 15.22309, I think 2 of them are of concern to the board. Was it acquired in good faith and any hardship not created by the applicant? Well, it was acquired in good faith. You saw the reference to the advertisement. And the hardship was not created by Charles Wood. It was created by Dick McNair and the people that did it back in 1999 who chopped off this unusable lot. And that's the very reason why we have variances, as referenced earlier. The second thing we need to know is that under subsection 4 of that, granting of the variance does not result in a use that is not otherwise permitted. Well, we know that a use of a single-family dwelling is a permitted use in agriculture. And what I did not know existed before, but I did find in the presentation of this particular hearing, notwithstanding any other provision of law, general or special, the property upon which a property owner has been granted a variance shall be treated as conforming for all purposes under state and local ordinance. So this is how we cure issues that were created back in 1999 by maybe the improvidently granting, chopping off of a particular piece of property. Now we can fix it. Now the issue is the degree of the variance that the people at Charles R. Wood want to have. It was suggested by one board member that, there's any number, I think was the word that was used, any number of structures that can be built on this, assuming it was a buildable lot, as we did last time. I went to the internet and pulled up at least 3 shotgun houses. Each of them required at least 24 or 25 feet width. And if you use your original variant of the original lot, side lot, and front setback, you can't get that house on that property. I could find no house plans that allow that to be done. But if you do make it 20, 20, and 50, the house they want to build there would go on that property. So for those reasons, I asked the court, the BZA to grant the
What is
variance.
20, 20, and 50, that's the setbacks?
Yes, sir.
Okay.
20, 20, and 50 for agriculture, yes. No, that's what they need. It's 50, 50, and 100 for it.
Yeah.
And that's the footprint that no house can actually be built on. And the concern again, that, okay, it's a lot, but you can't build on it. There's this legion of case law that says that's essentially a confiscation of property. And that's a road nobody wants to go down, I think. And it was something done back in 1999, but I think.
Was it done in 81? Was that when we wanted what?
I've got date 12/3/99 boundary adjustment.
Oh, the boundary adjustment.
In 1981, they broke off this acre.
Oh, yeah.
Okay, so,
But the boundary adjustment, which still showed 2 buildable lots, was done in 1999.
and was that signed off?
Signed by Dick McNear, I believe.
No, John McCarthy.
Oh, that's right, okay.
Oh,
Signed by,
the signature is probably like a swiggle, right?
it is, it's a J.
Yeah, but it's
Yeah.
probably.
John, 2 of them, I apologize.
No, that's fine.
So that's our position, and I appreciate the fact that, we may think it's a mooted point if there's a non-buildable lot. That's a separate animal for a separate hearing, and her determination of whether it's not a buildable lot will be likewise appealable to this board. Now, if we want to take 2 separate matters up tonight and vote on the variance first, and then vote on the other, which we don't really have a lot of information on, that's one way to do it. And then they vote.
What is the other?
Well, the other one is that it's not a buildable lot,
Oh,
which I think is mooted. I don't agree with that, and we'll have our day if that's the position she takes.
Yeah, I saw the email.
I have a question. Is I didn't see it anywhere in there that anybody actually state that it was a buildable lot. We have a lot that has all the qualifications for a building.
But I think
But what I'm wondering is if the problem is not, is that you were, your clients were victims of false advertising.
Okay. And what my position is, aside from that, say they just stumbled upon this piece of land and they thought that was nice. They go to the record room and find an approved plot by Mr. McCarthy back in 1999, which appears on its face to be a buildable lot. And recognizing that when the government, county government, approves a lot that's been cut off, a lot is a lot, but it's also, you just can't make a lot that's approved by the government and then not be able to use it. You don't need a lot to do farming. And this,
Agriculture.
yeah, it's agricultural area, but you can see I pulled all the maps that are on the internet and whatnot from the county government. It's not prime agricultural land. I know there's concern about the watershed and whatnot. There's already a house right next door that put septic into this
That
medical.
couldn't be torn down, that was there, and even though the subdivision was, not correct, I suppose you might say, that doesn't mean that the house needs to be torn down or had to be at the time in order to get it to work. You can't go back and tear it down, you can't say that just because it's there, you deserve to have one like it, because you can't tear that one down.
Yeah, well, all I'm saying is, in order, we have the environmental concerns that were raised maybe at the 11th hour recently because of the response to the email. The health department says this is a lot that could be perked. So, and I'm a hiker, so I know that every babbling brook that comes down from the Blue Ridge Mountains feeds into some type of watershed. I get that, but I don't know that that's in and of itself a basis to deny a variance. I think what we have here is a non-conforming lot which was approved at least maybe twice, if not maybe twice, by Mr. McNear and Mr. McCarthy, and the people who presently own it are simply asking that you make a variance to allow them to put a house up on that lot so they can use the property that they own, so it won't be essentially confiscated by the government. Because a lot can't be built on, because that's why we have variances.
I don't see that it was, that at any time originally declared by Dare or anyone else to be anything other than a lot.
Well,
Not a buildable lot
there is
by any
one,
means.
so one aspect of that is, my understanding, you can correct me if I'm wrong, there is an allowance for one dwelling per parcel. Right, the ordinance permits one dwelling per parcel, it doesn't matter how big the parcel is. Some parcels are not buildable under the ordinance because of setbacks or other things. That is what the variance process is designed to alleviate, because you could not accommodate every single possible situation. Now, the design of it, in my understanding, is to accommodate parcels that existed at the time that the ordinance came into effect, so that there would not be anybody who had a property and could not build on it suddenly because of the new ordinance. The difference in here is that it does seem like twice the county has had a pass at it to say, hey, you can't make that lot. But instead of saying that, they said, yes, you can make that lot. So they created, the lot was created with the county's approval. And
Right, it was the
81.
intent of the county to just.
the intent of
approve
the
lot.
county is they can have a home on it.
Okay, so you're saying is, that regardless of what it is, if the county approves of it, they can have a home on
Well,
it. Now we just have to sell the setback.
I'm saying that the way that it's created is not typical for why we have variances, but it is a fact that, you have something that ends up being created by government action, and it's 30 years, 40 years, I don't know how many years, like 40 years.
You know, it was our decision, now we should have to stick with it.
Well, it was the county, the zoning administrator approved it. Didn't sound like anybody appealed it or, raised any issue with it.
You still-
I guess I was thinking tonight we'd be talking about how much variance would be appropriate and that type of thing, which is probably more typical, but, I agree that if this is an issue that we're hung up on, we probably should, I would think we should resolve that issue somehow about the buildable nature of the lot.
I think you made a perfectly good argument that it's a buildable lot, but if they allow one house per lot, they have a lot that's one house allowable. Now, just the question is, where does it fit?
Well, that may be your position as well, but I think it would have to be the position of the board.
I think we've got two questions here, and one precedes the other. There is no need for a variance if in fact the lot is not buildable. So we need to get a determination, which I don't believe that we can make as a board, as to whether the lot is buildable. That's between the zoning administrator and the county attorney to look at all the information and come up with a recommendation to the board on what their feeling is.
I don't think that's actually.
So I think under the circumstances, we need to table this until the county attorney can take a look at this information and make a determination.
May I just suggest that what we probably would end up with there is not a recommendation, we would have to have a determination made, probably. And I don't know if we can maybe request that. But don't we have to render an answer on this variance, like within 30 days?
Not under the circumstance, not under these
No,
circumstances.
but
No,
under our procedure we do. Isn't
No,
that?
I think this would be an extenuating circumstance.
And
So
30
we don't
days-
run into this all the time.
Wait, 30 days after the hearing, right?
But if we ask for more information, it'll be 30 days after that.
Well, I don't know about that.
I'm just asking, I don't know.
We can leave it open. And I don't know what the right word is, not table it,
Well,
but
look in our procedures, do you have a copy of our procedures?
Oh, I do.
Because if you look under variances, I think we do have to render a decision within 30 days after the public hearing. And so I just want to make sure.
And I think it can be continued with the acquiescence of the.
I'm not sure, but maybe.
And we would not, because we want to go ahead and get the variance issue dealt with now. And I think because of the subsection I read to the board, which says, and I'll reread this because it's under 15.2.2309, powers of and duties of the Board of Zoning Appeals. And it says, notwithstanding any other provision of law, comma, general or special, comma, the property upon which a property owner has been granted a variance, and if it's granted tonight, it makes moot the issue of the non-buildable lot.
No, I get that.
Shall be treated as conforming for all purposes under state law. So what it effectively does is takes away the rights of the property owner from having that variance dealt with tonight as the public hearing has been
You
done.
mean what we're talking about?
Yeah, but the variance and what I believe from a legal standpoint, Charles Wood is able to do is get the issue of the variance dealt with. And if for some reason it's denied or however it comes out, it may be satisfactory to them, or they may want to appeal, but they have certain due process rights which I think need to be addressed. And if the board was to grant the variance, then I think it renders moot the issue of the non-conforming lot based upon that subsection of the code.
Well, I don't know that there's any debate that the lot is non-conforming, right? I mean, it's a non-conforming lot.
But there are a plethora of other positions that can be taken by the applicant that deal with whether there can be a non-conforming lot like we, and that gets us back to the variance. So that's why we have the variance procedure to deal with that.
Right.
And so from a time, money standpoint, okay, it'd be nice perhaps to have more time to have the county attorney look into it, maybe render an opinion, or actually be here for the proceedings, to talk to you about it. But the bottom line is, the people that were here last time, it was suggested by the board, I believe, that we continue for a public hearing, so they hired counsel. We're here ready to go.
No, we understand.
Okay.
But, okay, so it does say, and I mean, I don't know, Ron, you see it, don't you?
Well, it's right there.
Yeah, it says within 30 days.
The public hearing, right.
After the required public hearing, the BZA shall either approve or deny. I mean, I don't know, it doesn't seem to say that we can defer that.
I agree, and that's what I was
Okay, so yes, we can have the public hearing tonight.
No, we're having a public hearing as far as I can.
Have you opened it?
He ordered it last time according to the minutes.
Yeah.
Oh,
Well, I mean, this is a public hearing. You're talking about public comment, but that's not,
okay.
we've been around about that.
But anyways, so yes, so we are obligated
So
to
we need to render.
hear, but we do not have to make a decision this evening.
But we do have to make a decision within 30 days.
Within 30 days, correct.
Okay. I mean, yeah, I don't know that. But no, We're just discussing.
All right, you're thinking out loud, I get it.
Okay, yeah.
Just for point of reference, do you know the square footage of the part indicated on the plat?
It's 2,400 square foot, that's what it says in the application,
Correct.
correct?
No, I think he's talking about the remaining
So I want
footprint.
to know the buildable space under A zoning. And it's indicated on this drawing here, I've kind of darkened it.
Well, I think it's a matter of where you place the building though, because if you moved it back, then it can meet like 3 of the 4 setback requirements. See, and you're kind of getting to what my issue is their variance is based on the house that they want to build. So they're not really looking at other solutions and other houses that they could potentially build. They're based on, this is the house we want to build, so we need a variance for it.
But they may need a variance of some sort.
Of some sort,
Yeah.
but I mean, here, they have it placed to where we're given a variance where it could easily be put back and meet the setback requirements of all but maybe the rear setback.
Yeah.
So,
And if I may address that, they're willing to work with the issue of the type of house. But as you can probably anticipate, people come with their first request. It's like when you sue somebody in a personal injury case, you ask for $250,000, you don't say, but I'll take 10. You know, you come with the house plan you'd like to have, which would fit if you got a variance to the non-agricultural 20-20-50. However, it's like I said, and I'm not sure if you were pointing to the residual space had it been in a buildable lot in the first place.
Right.
Okay, that's what I thought he was asking. If you look at that,
Just this
it's not a 2,400 square foot house. It's essentially a shotgun house, and that's what.
Right, that's what I was wondering, what is
And
that
that's,
square
there's,
footage?
it's like 20, it's like 20 some feet maybe.
You're talking about like a row house.
Well, I've got pictures of Bob Vila has these things on the internet.
well, if it's further back though, then you could meet the setback requirements because it's an L-shaped lot. It's because if it's placed more towards the road, then you're having to get setbacks on both. If the setback is on the back, then it could be moved back into the right and meet the side setbacks and the front setbacks.
Yeah, what they're telling me, I think, I'm reading between the lines, is that they're willing to work with you on some of these, but maybe move it back. I mean, well, you don't really need to move it back any further because it's already 100 feet from the front, which is where you want it anyway. So,
Well, I do think it would be good.
I mean, where do you anticipate would be I
What
know
I'm
it sounds
suggesting-
like we're negotiating this at the hearing, but
I'm just trying to say that there is a variance requested for 2 different setback requirements for the sides. And it's for this particular house. And we
Right.
haven't really investigated, and the applicant hasn't really investigated what other homes could potentially be built there. And my point is just my cursory look at this. If I shifted this house
Yeah.
back, then I can, and to the right, I can meet 50 foot here, 50 foot here, 100 foot here, and only be requesting a variance from the back of the home.
Right.
yeah, 'cause I'm looking at the same house and I don't see that. Unless you're talking about a different house that we don't know about.
You mean a different?
A different architectural rendering of a house that we don't know anything about.
Yeah, that's right.
So what it does, I mean, you all
Isn't that
can,
right?
Well,
Does anybody else understand what I'm saying?
Yeah.
I sort of understand what you're saying, but I discount it because there are houses that can be built on that footprint.
okay.
I mean.
and that's the position you and I
What I
respectfully
was
disagree on.
saying is that shotgun houses traditionally are 12 feet wide in New Orleans. They're not 24, they're 12 feet wide. They're very narrow, long houses. They've been there for years. A brownstone, different type of house, they've been around for years in cities, and they're traditionally in the cities, they're right next to each other, whatever, but their average width is 18 feet. I've got a plan here for a freestanding brownstone, and this particular plan is 21 feet, but it could be adapted. It's 3,000 square feet.
No.
So if you have an 18 by 76 foot footprint, yes, you can build a very livable structure on that footprint, so there's no need for any variance.
So that's assuming it's a buildable lot.
I can see,
Assuming it's a buildable lot, yes. I mean, we sort of gone beyond that, I thought, but that's the point, is that it's creative design,
Right.
but yes, you can design a house that fits into the building space on that lot. Now, when you bought the lot, it said, and I brought this out at the last meeting, it said that on the real estate advertisement that the zoning was unknown.
I read that, yeah.
That's very odd. You don't see that in real estate advertising very often. And as a buyer, your due diligence is to find out what the zoning is. And when you knew, if you did that, you would have realized that you were going to be buying a lot that had these required setbacks.
So that gets me back to the Spence versus City of Virginia Beach, where the person actually knew it was a non-conforming lot, actually knew there was no way to build a house, yet bought it anyway from the guy who was unsuccessful in getting a variance. Came to the same board, got a variance, and the Supreme Court of Virginia said, that's fine.
Well,
There's no requirement
That's a very
that,
yeah, yeah.
and my job is to advocate on behalf of the
Absolutely.
and if there's case law that suggests that,
Didn't you pass that down?
But our job is that,
Just move this.
as I'm sure you're aware, is that you have to be very careful with variances. And there has to be, the hardship has to be, has to be real, and it can't be created. And by buying a property and not realizing what the actual setbacks were, that is created by the person that purchased the property. They did not do their due diligence.
and I appreciate that position. I read that and anticipated that. That's why the Spence case is so important to this, the board, because the person in that case actually knew that it didn't meet the requirements of the building lot and knew that the board had just recently denied the variance. And he bought it anyway and took a chance, and the Supreme Court said it doesn't matter, that there's no good faith. The bottom line is, from a variance standpoint, that those five, it's tough.
No, hey, yeah, Larry, so,
You can't help.
yeah, we should probably judge
What's
that.
going on.
As long as those five elements of the requirements for the purpose of the variance under the Board of Zoning Appeals is to address issues where someone has a lot approved by a governmental entity, they're trying to use it to its highest and best use, and they are hamstrung because under certain zoning regulations, it's deemed not to be a building lot. However, so you're stuck with either two triangular shaped lots in Virginia Beach or a 0.9 acre lot, which is signed off on by not one, but two zoning administrators over time. It's really no different under a real property law that subsequent purchasers are tacked on to the rights of their original owners. So say this was the original owners and this was their grandchildren. And they're here saying, Granny and Gramps had this, we want to build a house. Well, Dick McNear or John McCarthy shouldn't have done this. Well, we didn't know that. And so I think the Spence case really suggests strongly that the due diligence argument is why we have variances. If you're going to deny variance, that's, I guess, within your power. But they all, or if you want to defer a finding and come up with some kind of adjustment in the side setbacks and the front setbacks that you think are appropriate as BCA members under your authority, that's another thing. But they come here hat in hand with a proposal of the house they'd like to build. And
that's, that's also, I think, part of the issue is it's the house they want to build.
Well,
And that clearly in case law, that has been challenged on numerous occasions and found to not be the case. And that, yes, this is what you want to do, and that's why you want the variance, but you could do something else that would meet the requirements,
But,
and so no, you can't grant variance.
but Ron, we have granted variances to properties to allow, I mean, we haven't restricted them to, what did you say, 12-foot wide house? I mean, we haven't required that. I mean, we've
We
made
can't
adjustments.
make this up.
We're not making it up. No.
You're saying that we in the past, what we did in the past may or may not have been correct. There's all kinds of variances that have been granted in the past that have been overturned by higher courts.
Well,
So we can't say, well, we in the past have done this, and so therefore we set a precedence. No, we don't set precedences when we make these rulings. Because, you know, they have to be within the scope of the law. And
Well, I mean, to me, a question is not so much, can you fit a dwelling of some proportion, but a reasonable dwelling, to me. I mean, it doesn't necessarily mean it's 2,500 square feet with, you know, master on the left side, but.
Wraparound porch, I get
Yeah,
that. And-
but I mean, it does seem like to really finagle it around, so you get it in there somehow. That's not necessary to me, but it is not necessary to give whatever someone wants either. So we have typically have gone in and made adjustments.
if there was a hardship,
Well, I mean,
So it is kind of a hardship.
show me the
well,
hardship.
the hardship is that it's, as you attempted to say, an unbuildable lot in a sense. Now, it's not totally.
No, I'm not saying it's not. That's apples and oranges.
Actually, if I could.
The zoning administrator brought up,
Could I finish?
yeah, go ahead.
Okay, so it's a hardship in that it's a uniquely configured lot that cannot have a typical house built as, I saw it. Other lots can be, other properties can be done, so you can give a setback variance of minimum. Now, we're not supposed to just give whatever they want necessarily, but
And we
we
appreciate
can adjust it to some configuration so that a reasonable house can be built. Now, okay, but I'm not suggesting that whatever the applicant asks for is what they have to get. I think a reasonable house is something that can be determined. Go ahead.
So, Bill, I think what you drew there was the point that if you bring it back, you can meet the setbacks on both sides.
But you would have to get a
You
variance.
can-
You still have to get a variance on the side.
But is it some physical characteristic that would prevent it from,
I mean, topographically speaking?
Yeah.
I don't think so. I mean,
would there be?
yeah, not that we're aware of.
Okay.
Okay, then let's bring up another point. Under special permits, special exemptions, general standards 170-52F. The proposed use shall be such that air quality and surface and groundwater quality and quantity are not degraded or depleted to an extent that would hinder or discourage the appropriate development and or use of the adjacent or nearby land and or buildings or impair the value thereof. This property is in a watershed. It's in the foot of the mountain run watershed. If you've been to I don't know who's been to the property, there is water flowing through that property.
But that's what I'm asking. Is there a reason why, because of the physical nature of the property, why?
How do you explain that? Let me
I'm
finish.
hearing you.
The foot of the mountain run is a tributary to the Rappahannock River. And it flows right through the middle of that property. That's why there's all that water flowing through the property.
Okay, so.
So
again,
if you build a house in the middle of a tributary of the Rappahannock River, that's an environmental issue.
Let me ask a question. Are you gonna build in the middle of the stream?
It's not just a stream.
No, but you're gonna stay off of the stream.
it's not just a stream. If you go and look at the property, Alex, there's water all over it, correct? There's springs. I mean, it's just there's water flowing from different directions all over that property. It all comes down to a conduit that goes under 522 in the center of the property. That is the run. That is a tributary to the Rappahannock River.
We're talking headwaters here.
What?
That's
say
the
we're
issue
talking-
that was dealt with by the health department.
The DEQ would be overseeing that. I mean, I actually spoke to them on an unrelated matter, and they're all over these type of things when the time comes for the permits to be issued. That they would not let a house be built over top, essentially with an aqueduct or something underneath, feeding the Rappahannock. And I'm not a hydrologist, but I did take earth science, and every stream that comes down from the mountain is going to feed somewhere. It's a watershed is everywhere that goes to a major river. Rappahannock is one of the 4 major rivers in Virginia. So everything at a particular point is going to be within the Rappahannock watershed. I get that. But this, and if that's what this board wants to deny the variance on because it's a watershed, I'd like that to be in the minutes. Because I don't know that that's within the ambit of what we're talking about. You're talking about a variance and setbacks. It's a completely geometrical issue when it comes to the zoning issues about where a house can be put on a plot of a lot. And the rest of the things that are beyond the scope of this proceeding, whether a variance should be issued, DEQ, that's why we had the Department of Environmental Quality in Virginia, and they ride herd on this stuff.
But we don't necessarily have to approve a variance to the house that you specifically want. Like, you just, I mean,
Yeah, that's
2,400 isn't a modest sized home, it's a pretty big home.
Well, I agree with you. I said we're willing to work.
I mean, that's my point also is that as proposed, it is the way the house lays, it's across most of that area. That water has to go someplace, it has to remain unpolluted and free-flowing. And that may be why this thing got approved as a 1.9 acre lot, and that Big Bear knew that that was a watershed, and that if it was 1.9 acres, you couldn't build a house on it. And I don't know if that would be the case or not, but that's a possibility. So, and I also have not seen anything.
I don't think they wouldn't do that. They wouldn't create a new lot for that purpose. They would.
I haven't seen anything, and you know, show me where it is, because I don't know everything. Where there's a guarantee that every lot that is created is buildable.
The ordinance allows one dwelling per parcel. That's what the ordinance allows.
It does.
So
What is the point then?
If a lot was unbuildable, meaning it was the side of a cliff and you couldn't build on it, yeah, you can't build on it.
No.
But
It doesn't meet the minimum requirements.
No, if it's buildable, physically buildable, the question is, can it be built within the setback? That is the question.
It's buildable if it's 2 acres.
That is the,
It's not 2 acres.
No, forget that. Okay.
No, don't forget that. It's a 2 acre minimum. So why do you allow someone to build on a acre and a half in a 2 acre minimum area?
That's what the variance process is for.
No, that's for physical. The variance is more for physical properties
And
on a lot
properties
that prevent.
and properties, yes, physical and properties of such dimensions that they cannot meet the setback. It's unfortunate that the parcel was created the way it was, but I mean, at some point, you've got to look and say, well, the county approved it.
Yeah, not only.
And the county
once,
approved
but at least twice, and maybe 3 times.
And they should not be making something not conforming.
Well, they can't say a parcel, if the rule is that a parcel can have a dwelling, they can't say, we're making a parcel that can't have a dwelling, just by making it too small.
What happens when it becomes residual?
Huh?
Well, that's different.
Not
different.
necessarily.
I think one of the salient points is, and I'm not sure this is even within our purview, but it sounds to me like we're talking not just a watershed, but it sounds like we're talking about the actual headwaters of this river.
It basically, if you
Well,
look at it,
drains under 522.
Right, but this
You
old
can
water's
see
just coming out of the
pictures
wall
of
all the way
Yeah,
around.
and it's basically a stream, but
Is-
Yeah,
Are we saying it's the
not-
headwaters of the Rappahannock River?
No.
That's not.
no, it's not.
No, I'm just asking.
Okay.
Headwaters
It sounds to me
farther-
like
yeah.
headwaters coming
It is-
out of the wall.
it's the third tributary. It is the third tributary into the Rappahannock River.
I understand that they're tributaries.
Okay,
That's
so-
the record, if that was gonna be the basis of the vote.
Okay, so we're not voting just yet. So, how about this issue of, do we need a determination from Michelle about whether the lot is buildable?
I think we made the case very well that it's buildable, but, the question is, kind of fit within is there a space on the lot? And I don't think the shotgun fairly represents the buildable space, but I think there is a space on the lot that's buildable, not quite as large as they want, but probably at least twice or 2.5 times the size, maybe even 3 times the size of that shotgun pit thing.
3 times the footprint?
3 times the
12
square
foot is what I think the reference was earlier, which is
Well, that would
relatively
be
narrow, it's just
36.
over a basketball goal.
But
That would mean if you put the house back so it was like 6 inches as the right-hand property line that comes down from the middle of the property. If the property house was built 6 inches back of that, then the side would not be 20 feet or 50 feet. The side would be all the way down to the far end of the lot down here.
in which case you would.
So you don't need that, you wouldn't need to ask for that 20 variance, or you could have the variance not, the side would go to what, hundreds of feet?
Yeah, or the picture you drew earlier, did you still
Yeah.
keep that?
Well, we had it for someplace.
I don't
Did it make its way down there and not get back?
No. Oh, there's a.
There it is, we found it.
Oh, yeah.
That's nice. I know, not that, that's assuming the size.
But without a variance.
Make it smaller, move it back, done, you don't.
Yeah, right, exactly.
Along
Yeah,
with
that's
this
what
line.
you do. That answers
This line here.
Or you can build this on there.
Well, that's.
I'm not sure, I don't think they want to do that. They have a normal house, they just move back, make it smaller.
But what, I mean, Kent is pretty close.
Yeah, I get you.
It would be pretty close. Isn't it 50 on the side?
It's 50, 50, 50.
50/50, 100.
And they got 50.
If they move it down though, off 50 up to this other end of the house, I mean, it's gonna be like 100 foot.
Oh, good
No, that's what I'm saying,
This is the issue. If
It's a
this
special
front
written
was
permit,
moved back
so
to
it's-
here,
It's one of those
then
environmental.
there's no issue, because it goes all the way down here. This isn't touched, is it? Can you zoom out? Can you zoom out?
Oh, no, they don't.
They don't have, we all we have is some type of
This is
property.
50 foot. You have all of this.
She said.
So that's what I'm saying, if they just move it back.
But that reduces the setback.
Well, there's, I mean, part of the problem also.
This is 50 foot right here.
Yeah, but how far can you move it back?
You can move it back to here, and the house can end here, and it's just a smaller
And that was
house.
the concern, I hear what you're saying, that was the concern the three of us had over here about not knowing where the sanitary septic area, whatever.
But you have that whole long.
I don't think it's, I don't know whether that,
I was gonna say,
that could be one worse here, I don't know, they don't want to put it on here, so.
Okay, I have another question.
Let's get to everybody here, so we can,
For you all, in
So from
My understanding on the application you sent is that the health department
so
had approved an alternative,
before this line.
That's correct.
acceptance,
Yes.
which is, so does not require a drain field.
So you still have.
It is a,
I think it requires a site.
what?
I think it requires a particular site. I don't know that it requires a
It's a
drain
very
field.
small site though.
Yeah.
It's a chemical process with drainage, but no, it does not require the square footage. Or near the
And
square
there's a
footage.
similar type thing in Falk here, which is literally on the Rappahannock River near my house, which they allow. So maybe something that's, probably doesn't have an issue with going directly into whatever fluid would be.
Right.
Oh, off the corner.
Or we decide on a septic process or system.
It's going to be one of those alternatives.
We'll have an
Sand type.
engineer.
I see, I was thinking it needed to be 50 feet here.
But you still have.
Irrigating garden.
I see what
But
you're
you know.
That's above my pay grade.
But see, just moving it back, you're still within 50 feet, I mean, less. Right, I mean, is that, in other words.
Yeah, we've been looking at a similar drawing here, which suggests that if it's brought back, I think we only have to, the suggestion is we don't have to change any, but we don't know.
But see, you
Right,
I
so
think
he said this,
there.
if it's back here, it's 50 feet here, it's gonna be 50
Like,
feet
you
down here.
move down here, but then you're gonna give up.
Oh,
Right.
okay.
Yeah, it looks good on, it's actually 20 feet
Well, at
from
least-
that
at
corner
least,
line.
reduce the-
line.
Yeah.
So that's, even though it looks great, that's, I think we missed that
Yeah.
aspect.
Yeah, we missed that, yeah, right.
So are we saying that the water's not an issue?
I think the building, when you get into the drain field and everything, they're not gonna approve, have they got a drain field site?
No, we're talking about, they're looking into,
It's an alternative system.
Okay.
according to the filing, I think that the health department has suggested one of those alternative sites that would go well with this particular type of lot.
Okay.
So it's been approved for that purpose for 3 bedrooms, it just hasn't been fixed by the people in the health department.
I mean, my question is then, if in fact you put a house there, how do you deal with the water that is coming down the run that is going to the Rappahannock River? I mean, you can't just stop it. Where is that going to go? And in fact, in the process of doing that, it could end up being diverted onto neighboring properties, which would not be allowed. So so basically, I think under these circumstances, they need to bring us a plan that deals with the drainage also. So we know that the drainage on that property, which is going to what Rappahannock's about, is the Rappahannock River, and this is a tributary to the Rappahannock River, one of the first ones in. It's a water source. You can't cut it off.
Can you
And
show me where
you want to
this-
ensure that that water is not infected, polluted or anything, so there's gonna have to be an approved
Wait.
system to
Can you
deal
show,
with that
where
water.
is the stream on this property?
Right there.
Where is the property line?
The property line is where it goes underneath, the house is right here on this map, and the property is right here, but the water all comes down, and the culvert goes right underneath the road.
But the house is not on the stream.
It's not just a stream. Did you go to the property?
No, I have not.
Sadly. Bill, did you go to the property?
No.
You have to go to the property, right? It has 4 different streams on that property that are all just flowing through the property. It's not one stream. There's all this water. It's a watershed.
Is this building here going to
Yes.
block one of
Yes.
those streams?
Yes,
It will.
yes, and probably even more than that. It's a hardwood swamp almost, because it's also in a swale. The road is high, rattlesnake is high, all the water channels right into that area. It's wet probably all year, and it's listed on the rivers maps as being a perennial stream. So it's flowing year round.
Which is the perennial stream?
But
That one stream.
This one stream.
No, it's a run.
So when you say a run, you're saying.
Meaning there's water flowing through the property from varying angles, but it's still, there may be springs on the property also. I don't know where the water's coming from, but there's water all over the place on that property. And it's part of the watershed that flows into the Rappahannock River. And that should be a factor in this. You can't build everywhere. I mean, you just can't do that. I mean, there's certain areas that, no, it's just not appropriate because, in this case, this water is going to the Rappahannock River. And eventually it's going all into the Chesapeake Bay.
So who would make this determination?
The DEQ,
What about a building permit? Wouldn't that affect the ability to get a building permit?
No, I don't think we got that, that's why we're here. I think we tried to go down that road.
we don't decide on, we don't know, we don't decide on those matters.
Building permit.
Other
No, that's what I'm
than
saying, we should have done building
No,
permit.
trying to figure out.
That's, yeah, so it's,
Okay, but let's just hypothetical situation. What if they said, Ron, we love that shotgun design? And they could just go pull a building permit and build that,
Right.
Right.
That's correct.
right?
That's correct.
Okay, so it is buildable lot.
Of course, yes. Unless, you know, now there are possibilities which is not our purview or whatever, but there are other people that might come in and go to the state and go, I don't know how this is happening, but there shouldn't be a house built here because it's in a watershed or whatever. But it's not going to be Rappahannock County, but there are private organizations or whatever, so they could face that hurdle also. But the DEQ, I mean, you got to protect the watersheds. I'm sure rat flow would not be thrilled.
Where are they tonight?
But
Where are they tonight?
they didn't know that this was happening because there's no address on this property. There's only a tax map number. And so you really don't even know where it is when you read the advertisement.
Okay.
Mr. Chairman, what are the options for us in moving forward? We either vote yes or no on the variance, or we table the discussion until the administrator decision, or no? Or it didn't sound like that was an option, so we have to.
Well, I mean, I think we were looking at the schedule. We could, within our rules, make a decision next meeting.
Okay,
If there was some more information we could get between now and then
okay,
that would assist, that would probably be helpful, although I think we could do that. But I think if we did that, we should be doing it because we're getting, some further information, not just to table it.
Right, no, I.
Well, yes, no, we don't make a decision tonight. And yes, there are, I think, quite honestly, in this situation, it would be very appropriate to get an opinion from DEQ.
Precisely. I think that's a really good idea. I think it's beyond our,
We don't know.
it's over our,
It
beyond
may
our
not be a
It's
problem.
definitely a problem.
It may be a problem, and
Legitimate
there may be regulations that we're not aware of that they would make us aware of, which would help us in our decision-making process.
and one more clarification, so what if it would be at the pleasure of the board to approve a variance for maybe a different footprint of the house? Is that
which it
something-
is.
Yeah, no, it's
Well,
up to
my
you.
point is would that be presented at the next meeting, or do we have to deny this variance and they have to?
Well, no.
I think
We can give what variance we think is appropriate.
So they could come back next
No,
meeting?
no, they don't have to reapply.
No, but they could basically present us another option, basically.
Well,
We
maybe,
can table it just for more
But we
information
can,
from both sides.
how can we make a determination on that until we get this other information? And that there might be a way, even from the DEQ or whatever, that yes, under these, in this particular area, whatever, yes, it would be okay to do thus and so.
Like build it on stilts.
But we don't know that at this point, so we can't sit here and say, we'll do this or that, and then wait and see what kind of information we get. Let's just continue it, get the information we need, and then sit down and make a decision.
Who's gonna get this information?
What?
Who is going to get this information?
Well, I mean, some of it can come from the county attorney, or, Michelle will take care of determining whether in fact it is a buildable lot. That's in her purview. And we can contact the DEQ and ask for advice under this situation, and that,
What, or soil and water, I mean, some.
We have two employees of the county that are soil and erosion officers. One's the building inspector and another's another official in the department. And I should think that they would be well versed in the ins and outs of this, and we could probably just ask the actual people who do soil conservation and erosion control and things like that. They'll know what the rules are.
I would be, how about we go to the
Who's
soil and water?
But who's we? Like one of us? Or...
Yeah.
Well,
No, I just asked.
I
that
can,
would be fine.
secretary, and
You
just,
can.
I could document.
whatever, yeah, I mean, soil and water could be very helpful with this.
Yeah.
Okay.
And that, because, and in fact, I'm sure what they would end up doing is contacting DEQ and then, getting a search determination, and that would give us an answer, because like I said, it's important to protect these watersheds, and this, again, it's unfortunate, or not unfortunate, but in this situation, it's becoming part of the issue, and it can't be ignored.
Does anybody know what the situation was in this neighborhood during the hurricanes where we had terrible floods and things like this? If this is the bottom of a bunch of mountains, it could be 8 to 10 feet deep there in a hurricane.
Well, that would render it unwise to build.
Yes, right. We might be doing them a favor if we guide them to the right.
But this is not what is called a floodplain or a flood zone, is it?
No.
It actually could, it might qualify for that at times, yes.
Right.
Because it is a ravine,
But hold on, it has not been so designated.
I don't know.
It would normally show on the plat survey.
Yeah.
Well, they just updated
This
this
isn't,
one.
we're not talking floodplain.
That's what they just said.
Yeah, no, but I mean, the peril here is not that the flood is going to rise, but that mountains are going to empty down this avenue. And were that the case, you could very well sweep a house along with it. Now, we wouldn't want that to happen for anybody.
Well,
And sometimes you probably get indications of what the highest height
Well,
of the in the past.
And I think the issue for the board might be from that standpoint, where do you stop being the zoning board and
Right, I
start
agree.
being the dictator of what are smart ideas for homeowners?
Oh, no, I'm not saying this is
I
not a
mean,
basis
I
for
get
our
that.
decision, we don't get to decide.
Well,
that.
we're talking DEQ and all this, and all we want is a variance. And I think based on the case law and going back to the statutory law, if it's a buildable lot for now, and irrespective of what the zoning administrator says, we got trains on different tracks, and we've got a public hearing irrespective of the nature of the notice that is complained about. So these people who own property, I think have, respectfully, can ask you one of three things: either to nix the variance, continue it for that 30-day period Mr. Sharp suggested you had a working area.
I think our next meeting, I believe, we fit within the 30.
Yeah, and you could come up and say, the five of us got together, we talked to DEQ, we talked to the water and soil people, we think this will work, what do you think? And, then that could be that's your variance. Or not, or just say no variance, it's not a buildable lot, which is a separate issue on a separate day, because she's not made her determination, although she waved the flag saying that's what it's going to be. She had to, after a cursory review, she may go back to their actual land record and say, good God, this issue I didn't see, Dick knew this, and John knew this, but we didn't know that, which are all things we don't know tonight. And I'm not prepared, and we're getting things of local knowledge, and I appreciate that. I'm from around here too. The fact that somebody's been to the property and said, well, the spring runs here, and other people haven't been there. Like I said, DEQ takes care of that stuff. They don't, DEQ doesn't talk about variances on lots, they talk about the water. So when the government's involved in the situation, it's attractive maybe to be the arbiter of good choices, but really,
Well, no, I don't think we're.
That's not at all.
But I do think that you have a point there about, just because the setback becomes an issue, suddenly we're gonna weigh in and say you can't build it. Where we wouldn't weigh in on
Yeah.
that,
I
you
agree.
said, I mean,
And so I also don't think we have zero expertise in,
right, but the only relevance that I see of that is if there is something that says, okay, well, this area should not be built on, and it happens to be an area, the only area that you could, I think it would be helpful to us to get that little bit of information, which would be.
and I don't disagree, and I think the next 30 days, if that information comes to your attention, that could be a basis for denying the variance, or coming up with a difference.
Or coming up with a difference and saying,
yeah,
okay,
building.
because, I mean, I do see a scenario where we minimize the variance by manipulating it here, totally not taking into account the water that seems to be critical, at least to one of our members, if not a couple. And totally ignoring that, but saying, okay, you can build a shotgun house here, or whatever we would come up with. But it may be that there is no, there is some other configuration that would make more sense. So that would be my reason for continuing. And if we do have some sort of discussion with DEQ or soil and water or whoever, I think that might generate information that would be relevant in the meantime. To me, it doesn't necessarily hinge upon that, but I don't think it would hurt.
No, I think you're right.
But if we don't have that information at the next meeting, I don't think that should be always preventing us from making a decision.
I agree, and then I guess the determination letter may make all of this a moot point.
Yeah,
Well-
just to interject,
No, I
depends
know.
upon when the letter comes out and their appeal rights of her determination to this board, it could actually go beyond the 30 days. So you would still, as long as the appeal process is there for Charles R. Wood Builders, Inc., from her determination, they could actually file an appeal and it'd be to another date beyond the 30 days. So it doesn't really make it moot. And that's why we wanted to get this done tonight so you all can make a determination. So, because they have a lot of appellate rights if they wish to, as you all well know, sir, you even made reference to the fact that some of your determinations are reversed by the circuit court. That's true. And they may get back from a business standpoint and say, they denied our variance or they made this variance, whatever it may be, they may want to appeal it. But they have certain due process rights which need to be addressed by the government, and that's us tonight.
Okay, so in the sense, I agree with you in the sense that I think if we do continue it for 30 days, we would make a decision at that time. I think that's reasonable.
Yeah, well, that's definitely reasonable.
And we don't disagree with the authority to do that, and we think it's great. And frankly, and I think I do speak, because I get paid to speak for these folks, but if you all come up with a configuration like we thought might work here, but ended up
Well,
not
actually,
working.
as you pointed out, I've made a
Yes.
mistake, but the thing is, if we were to grant the one variance of 20 at that one side, then that would actually expose the variance all the way along that side, which would mean that you could have one variance on one side and actually have more square footage available to you.
And that's the thing about the procedure for a variance, before the BZA, we get the ball started with the request. And this is what the request was. And I hear everybody speaking about different issues, and that's understandable. So we have this 30-day window for you all to get together and deliberate. And if you come up with something that you think is in the best interest of the county of Rappahannock, that's great. We'll know next time. We'll take it back to corporate office, and they'll look at it and, hey, that's a good idea. It's not a 12-foot wide house. It's whatever it may be, something more reasonable perhaps in their estimation. And
Maybe you could check the topography of the land if we end up thinking that it would work to just do the one the one side, make sure that's gonna work on that.
Of course.
And once we get whatever your determination is, whether it's a denial outright, or an alteration, or a complete concession, 4-1, or whatever it may be, then we'll take whatever you all say and go back to corporate and look at the land and see if there's anything we can do. And because I think based upon the application, they felt like this house would work. And I get the fact that some of us think it's a gargantuan house on this particular piece of property. And if it's something smaller and they can live with it, and you all can live with it, that's why we had this type of hearing.
You might want to look at the National Geological Surveys, because they do topographies of places like this. I'm not sure that the detail would be small enough to give us a lot of help there, but some topographic understanding of the property would be a big benefit.
And they have engineers who do that, they get paid big bucks for that, and that's something they're gonna look into.
Address Ron's concerns about where the flow of the water is, the topographical.
And from the applicant standpoint, and I appreciate that, from the applicant standpoint, we get a list of things that you all want, and we gave it to you. So all the stuff that's come up about hydrology and topography and things, we're not asked for this hearing.
That's
So
true.
if that's something you all want to get into in the future, maybe it's something you should get into in the future. We were given a list of things and we gave it to you, we're here for that purpose. So.
Yeah, we
All right, mention that.
Okay.
So,
Talk a lot.
okay, so what, does it seem like the consensus is that we would continue this till the next meeting? And that is within the 30 days, is that correct? And so then for a decision on that day, and then there's some information that we will look into, but regardless of what we get, we will make a decision.
Well, it's gonna be, yes, based on, I mean, that's why I think that's why we need the information. And then we can base a decision on the necessary information, and it's gonna take 30 days or 28 days to get that information.
So this other thing that is not necessarily, would not be totally resolved by that time, but Michelle's idea of it not being buildable, is that something that's been requested? Is there a determination, has that been
Yes.
requested? Who requested it?
I'll request that.
No.
She brought it up, and I think it's a relevant issue.
But is that,
Let's get a
so
determination on that.
you would make the determination?
Before the next meeting.
Oh, yeah.
Yeah.
Yeah. Okay. Well, I mean, I guess that would be of interest. I don't
It
know.
would be of interest, like it's a train on a different track.
Yeah.
So,
But
and there, depending upon that and depending upon your ruling on that, upon appeal, which I can anticipate would happen if she said it was not a buildable lot, for the very reasons the four of you all perhaps look differently than the gentleman here. Then we get here, and depending upon that outcome, then we maybe, if that would render moot arguably your variance issue. But the bottom line is, if you were to vary to a lot configuration that the gentleman here would be okay with, something maybe more than 12 feet wide, but less than whatever, and everybody said, these variances will work for this lot. And I got back to the same code section that says, when you all make that determination, that trumps the rest of the
I think I would agree with that. I mean,
So we're not willing, we're not saying it's all or nothing. We're willing to work with you, but we're following the process that we're given. And that's where.
And, I mean, quite honestly, I mean, we're not necessarily the final answer. I mean, our decision.
Well, for now.
Yeah,
For now, yes, but, I mean, you can bump it up if you don't agree with it.
Well,
But some environmental organization may come and trump us all and say,
Exactly.
this is not a place where you can put a house.
And I don't want this-
The document's moved.
Exactly. DEQ may say something completely different and render this hour and 15 minutes moot.
But we
But
didn't ask.
But like I said, we are not about bumping things up. We're here about working within the system. So, to the extent you may feel like I'm threatening things, I'm just trying to tell you what their options are. It may be a different lawyer, but they say, I didn't like the way Asheville presented their case. And it may be somebody from Fairfax or someone who feels differently about the way things are done. Bottom line is, we're trying to work in the system that we were given. We gave you what we had. I read the law, what I think is the proper interpretation. You all want a 30-day continuance to look into the answer so you can render one of three choices. That's great. We're all about that.
Okay, because that sounds like that's what we're inclined to do, right?
Yeah.
Okay.
I'll make a motion to continue the public hearing until the April 28th meeting
For the rendering of a determination,
for the rendering of a determination.
friendly amendment.
Thank you.
Yeah.
I'll second.
And, okay, and so I never did open the public hearing of the public comment portion. So we will.
Yeah, let's back up.
No, hold on.
No, because actually, we can put that over.
Hold on, just before we do.
Oh,
The public will be able to speak next time.
Correct.
correct.
That's what I've.
Right. Oh, yeah, absolutely.
Okay.
Well, we can open it now.
I mean, there's nobody here.
Yeah, there's nobody here at the public hearing, so
Well, we're continuing
We
the
are.
public hearing.
I thought the way you read your regulations or rules that you could continue for the delivery of your answer.
Well,
And if to the extent you believe that it
Yeah, but
means
I don't know.
differently,
We can.
I don't think it prevents us from,
Continuing the public hearing.
Yeah,
oh, you
well,
know what, well, you don't want to go down that way, because we could probably continue it after the continuation.
well,
But I don't,
different.
we're not gonna do
I've got
that.
some state.
No, we're not going to
Okay.
do that, we're not going to do that. I'm just saying, it's my intent that if somebody wishes to speak next time, that we will let them.
Okay.
I mean, I'm just telling you that. Okay, and so that was your motion to continue?
Motion is continue the public hearing
For
until
a
the
decision.
April 28th meeting for the rendering of determination.
Is it 28th or 22nd?
22nd, is that the second?
Yeah, that's what
Second, no, that's not second, it's before.
Yeah, it can, yeah, it can.
Is it the 21st or the 28th?
Well, then
The
first-
Wednesdays are in April, or the 21st or the 28th. I have it as the 28th.
Oh, the 21st.
In 28th.
Wait, hold on, that's not within the 30 days. Hold on, make sure about that, 'cause I thought,
7, 14, 21.
who said, did you know about that?
We'll see what, who's this one?
That's 35 days.
35?
Is it April 28th?
But this one says April 22nd, 2021.
Those dates aren't correct.
Yeah,
And
That
that's,
is-
right.
It's April 28th is the
was
last.
this the final one?
It does not have been.
I thought we caught that.
Yeah,
Someone caught
I
that.
think I must have tossed it around.
Who's got, does someone have the latest one? You do, you must have.
No, I know.
Michelle, do you have the latest count?
The 28th.
Oh, it is definitely the 20th.
Yes.
Oh, okay, well, I'm glad you caught that.
That's 35 days, by the way.
If that was 35 days, then we can have a mutual agreement with
I don't know.
if they're willing to extend the date.
That's what I get back to. We were willing to get it done tonight, and I get the fact that you want 30 days to kind of deliberate amongst yourself. And I
Well, we
think that's
never
a-
actually deliberate amongst ourselves,
Well, you could. This could be the time you do it.
but we can.
That would be ex parte,
We're just-
wouldn't
We're
it?
just looking for information.
Okay.
So,
And so, I think, I'm not in a position to waive any statutory or right under an ordinance for them to, because what we're looking at is your continuation of the public hearing, and using a hydrological term, the floodgates will open arguably, and we'll be here with new issues that, I think the issue of the watershed, if I can read emails properly, was a surprise to you when you read it and you got back to us. So there may be a new surprise 35 days hence. And it'll be a whole new thing that we're not prepared for to talk about in the issue of a variance. So it's either,
could we do our meeting at an earlier date? We could.
I don't know if we'd meet the
We
advertising.
can't,
No, we can, I mean, we've opened the hearing. Doesn't have to be advertised,
no.
we just need to send notice out. Do we have any business for the next meeting?
We do.
Yes.
Yeah.
Couple, what is it?
Yeah, I think we've,
I thought it was 30 days. So what else would we, because we really can't.
Well, if the applicant's not willing to give us until the next meeting, then I think then we make a decision then.
And, you know, our decision could actually request follow-up on the actual exact location of the building. I think we've done it.
I can't, I'm not gonna run your meeting, however you wanna do it is fine. I feel uncomfortable, being suggested that I agree with something that's beyond the
No, no, okay,
regulations,
well,
or B, if they don't wanna do it, then we can vote tonight type
No, no.
thing, and it's like, oh, what am I supposed to do on
No,
that?
no, actually, you may not have heard what I was trying to say. We have done it in the past where we have granted, like, the variance, but then have drilled down on the exact location of the house to come back for our approval. We have done that before. I don't think that's unreasonable.
And
Because there is a little more information that would be helpful in the exact placement of the house. I think.
We can have public hearing.
Yes. Oh, well,
I don't say much too often, but if you want to make a decision on this sooner than the 30 days, you could have, you can continue this meeting,
to a different
correct?
time.
They do it with planning, they've done it with the board. You can continue, and I'm looking at April and the 7th and the 14th, which are Wednesdays. I don't know how open they are otherwise, but I don't think there's any other meetings. You could come back then, that would be enough time for your administrator your people to give you some information, and then you could go have your regular meeting. It just means having a
So we'll do
continuation of
special
this meeting.
Good point. Yeah, we've done that.
Thank you.
Yeah.
Excellent. Okay, thank you.
Come on here.
That's very good.
I'll be here just to watch.
Yeah.
Would you be available, I mean, it's.
It depends upon what dates said.
Did you say the 14th?
The 7th and 14th are Wednesday nights.
Yeah, 21st is the planning commission, so that's.
The seventh
You can't do it, can't do it
work session.
7th is, so how about the 14th? Does that show okay? Seems okay? Okay.
It's 7?
14th.
No, at 7 p.m.
At 7.
Well, we don't have to be 7 p.m., but we could.
Mhm.
Yeah,
Which
I mean,
is
that-
seven.
yeah, because that's.
Well, earlier is better for me because
Well, what is it, 5? I mean, can we do 5?
I can.
Could everybody make 5?
5 o'clock.
We can do, yeah.
Can you do that?
I have kid issues with that.
So-
Weeks in advance.
We may have to make it 7. Okay, 7, okay, we'll make it 7.
And you'll coordinate the location.
Okay,
That's
Okay.
Just an olive branch of sorts. I mean, over the next couple of weeks, if you all talk about things and whatnot, and have an idea that you want to pass by us, please feel free. Michelle knows how to get a hold of me via email.
Yeah, we,
It's the type of thing, we're always willing to work. We just want to get something that makes this
yeah,
lot
okay,
viable.
if there's any email or loops, whatever, you are part of that loop, so.
okay.
Okay.
And then the boundaries of the property are pretty definitely marked. Okay.
Yeah.
They were in the photographs. I'm not sure what's transpired since.
Okay, okay. So the motion, would you be willing to amend it to the 14th at 7 p.m.?
Amending the motion, or that we'll continue for the rendering of determination to the April 14th at 7 p.m.
And that's just for,
Yeah, this will be-
that will be the only order of business there. Okay.
Anybody
Is there a
second?
second? You
I second.
We have 2 seconds, so.
And you have 2 minutes left?
Okay. See, that's very popular. Okay, any further discussion? All in favor? Aye.
All right. Thank you very much. I'll see you next time.
Okay, thank
Appreciate it. Conversation.
Thank you all.
Okay, thank you.
Stick around.
Okay, I think that's all of our, Bill, we're not over yet.
Oh, I'm sorry.
We're almost there. Is there a motion to adjourn? Is there a motion to adjourn?
I make a motion to adjourn.
Not adjourned, continue.
Continue.
Oh, to continue.
Is there was a motion to continue, she just did.
Yes.
So we continued that. So we're not adjourned.
It is.
Okay, so we're continuing.
I thought it might be.
See, we're done.
We were done. Okay.
Yeah, well,
I'm trying to be polite.